Hello, everyone. This is Seth Bloom from Levelset. I'm Senior Director of Attorney Services, and I'm excited today to bring to you another one of our excellent webinars with our host, Chris Ng, who's here today. And he's going to talk about what most don't understand about California lien law. I know we have a lot of things going on with the state of the world, and Chris will address that. He's the managing partner over at Gibbs Giddin in the greater Los Angeles area. So, Chris, I will turn it over to you right now.
Thanks, Seth. Good morning, everybody. My name is Christopher Ng, and as Seth said, I am the managing partner of Gibbs Giddin. We are construction attorneys that are based in Los Angeles with 3 satellite offices, including out in Las Vegas. And we represent contractors and suppliers in the industry with their construction issues, payment claims. And we sit on national groups and committees to help service our industry, again, primarily representing contractors and suppliers, although we do represent the entire chain of construction, so owners, developers, design professionals as well. So this morning's seminar was actually supposed to be a live seminar at the Beverly Hills Marriott. So a lot of you, I think, were expecting to be right there at the beautiful Beverly Hills Marriott near Rodeo Drive. That obviously did not happen this morning. This would have been our room, and yes, we even paid for the wonderful floral arrangements to be set throughout the room, and it would have been
don't forget the beautiful breakfast.
Yeah, beautiful breakfast. So in lieu of that, hopefully you are enjoying your own homemade omelets and lattes while we are here today talking about California Mechanics Lien law. And typically I always start with a graphic and a slide of the latest AIA forecast. And I do that for a few reasons. Usually it's one, to give the folks that are tuning in an idea of what the market looks like as far as growth and potential growth. And as we all know, when you look at architectural billings that are 18 months out, for projects that are 18 months out, we kind of get a sense, if those billings are still growing, how healthy the construction market is. And so for the last several years, we've been putting the graphic up, and we've shown that, hey, construction is still growing. Construction spending is still growing. And we are forecasting with the AIA's assistance and all of the consensus folks that they poll, that we're going to still have growth. Even if it's going to slow down a little bit, it's still growing. And we are expecting at least 1% growth in 2021. And I say that, of course, with a little bit of hesitation in my voice because of the coronavirus pandemic. And this has thrown everything out the window. And so what I would normally have started with about 3 weeks ago on this slide about the market has been turned upside down. So no doubt that this has taken an impact on us. And I like to start with what's happening in California lien law updates, like what are the new statutes that are out there that are impacting us in the industry. We walk through at a typical seminar those that are important to us, those that we feel on a day-to-day basis, those that will change perhaps payment processes and slow down payments, like 218.7, the labor code, which was the statute which holds general contractors liable for unpaid wages downstream. And we know that what was happening is some GCs and subs were getting in disputes because the GCs would be asking subs to open their books, let me see your payroll, let me make sure you paid everybody. Some of the subs couldn't do so. And so because of that, we had payment conflicts at that level, which were impacting lower tier subs and suppliers. And so we like to talk about some of the new statutes. We will get into some of these today as we walk through our presentation. We talk about new cases. We've had a few of them that have been pretty important, including precision framing, which was a subcontractor lien claim, which was declared to be prematurely recorded. So finding that right balance and when you record your lien is very important. Again, we'll walk through cases still today, even though we are talking about coronavirus a little bit in the beginning, and then we'll get into perhaps what a lot of you do not know about California Mechanics Lien law, what that means. So in the good times, as of a month ago, we would talk about, hey, even though times are good, even though it's a healthy construction market, we want to be proactive. We want to anticipate what might be coming down the road. We still don't want to wait on folks. We don't want to be always in a pay when paid situation. If we're a supplier and we have net 30 terms, we typically want to hold our customers' feet to the fire. They're the ones that owe us the money. We want to expect payment within that time frame. And of course, if you have a job account, you may be more liberal in that. You may extend your terms out because you know at the end of the day, you've got a mechanics lien right. So I have a few clips, and this one, if those of you that are fans of Narcos, if you watch this, it's first episode of this latest season of Narcos Mexico, some of you may have said, oh my gosh, they're talking about pay when paid. Of course, this isn't the cocaine industry, but nonetheless, this may be a conversation that you've had with your customer at some point if you are a material supplier.
Nosotros vamos a seguir pagando por cada kilo que cruce la frontera, exactamente como hemos estado haciendo hasta ahora. Y el dinero le caerá, no lo tenga. Y si no, pues vamos a encontrar otra solución. Usted puede volver a hacer lo que sea que hiciera antes de que nosotros lo convirtiéramos en un hombre rico.
So first time I've ever used a Spanish clip, but there you go. When we get paid sort of conversation. And we'll talk a little bit about that. That is probably of less importance in this climate, but we'll talk a little bit about pay when paid as well as we move on. So before we get into the main substance of the material that we had planned for you today about California Mechanics Lien law, I do want to talk about the impact of the coronavirus on ongoing construction projects. For those of you that tuned into the webinar earlier this week, or the ones that Levelset have been putting on regarding coronavirus, we talked a little bit about that as of last Monday. And of course, the climate's changed so much between Monday and today. We had 350,000 cases of coronavirus diagnosed in the United States on Monday. Today, we have almost 500,000. We have 3.3 million unemployment claims today. So the climate's changing on a daily basis. Shutdown orders becoming more rampant around the country. And here's the reason why it's such a big elephant in the room, is that as of a few days ago, the AGC had done a poll, had done a survey, and they had found that 30% or 28% of contractors say that their projects have been halted or delayed. And I would bet to guess that number is actually a lot higher. In California especially, we are dealing with conflicting orders, as we're going to talk about in a second, that make the analysis of whether you can even work on a project very complicated. So it is not just now supply chain delays and issues that are developing that are threatening our projects. We're worried for the last few weeks about what's going to happen when 30% of our materials that come from the Far East, when they are not coming on time. What do we do? What do we do with our steel shipments that are not going to hold up maybe structural development of a project? So that was our main concern. It still is a major concern of delay as we move forward, but it's becoming bigger than that. It is construction firms that are themselves deciding to shut down. It may be that some of them want to work, but they're having a problem because some workers refuse to work. They don't want to go to work because of the threat to their families and bringing home coronavirus. And even if firms are moving forward with projects, they are almost always ordered to do so using safe distancing or social distancing measures. So if you can imagine, if you are a construction worker, it's pretty hard to stay at least 6 feet away from everybody on a project at all times. It's almost impossible. And if you can, you are going to have impacts because of your social distancing measures in your efficiency of how you carry out a project. Even then, a lot of owners are shutting down projects because they're interpreting some of the local municipality orders very strictly, and looking at the state order, which may be a little bit more liberal, may allow public works constructions, but then in a particular jurisdiction, it's saying that there is no construction allowed, or maybe just housing construction. They may have different exceptions. And so it's trying to parse through that and figuring out what projects should be ongoing and what projects truly should be shut down under the various orders that are out there. So this noise and all the ongoing change is causing a lot of confusion, and really it is impacting, I would say, probably 30 to 50% of our projects right now, especially in California. We have on a daily basis, regardless of whether we represent an owner who's being impacted or a contractor who's just calling us to say, can we get back to work today? What do we do when the owner tells us to sit tight or demob? What should we do? What notices do we give? that sort of discussion is what's important and what's taking place on a daily basis. So clearly, as Levelset has some wonderful graphics, they have a great survival toolkit for all of you that are out there on their website, levelset.com. But as they lay out, clearly we're going to be impacted in the construction industry because of the supply chain impacts, because of the quarantine and the shelter at home orders, which will prevent or reduce our ability to do on-site work. Clearly, the larger financial issues, the ability to access lines of credit and funding is going to be impacted. And then just the legal disputes. Even though courts are quote unquote closed, or they are not taking outside visitors, doing stuff remotely, things are still moving forward, and liens are still being recorded, and lawsuits are still being filed, and escalate as folks are trying to figure out the uncertainty of the climate right now. So I would say that a thing that's more important than ever, that we understand our rights, duties, and obligations, and that we're not being the guy with our head in the sand, like this poor gentleman, and that we are actually being proactive as much as we can. And it's still an opportunity right now to be proactive in how you approach your projects and your job accounts, making sure that you are out front. You're doing this seminar this morning, so that shows that you are out front and you are interested in figuring out how you move forward and protect yourself, whether you're a material supplier, you're a subcontractor, or a general contractor. How do I protect myself and make sure that I don't give up my security and my leverage? And that's what it's all about when we're talking about mechanics lien rights. It's security, making sure at the end of the day you get paid, but it's also the leverage to say, I deserve to be paid, and I want to be paid now before those that haven't secured their job rights.
Chris, I just wanted to, I saw we got our first question, and to get ahead of things, I was going to go ahead and let you ask it, or let that person ask it once we've now finished the immediate Corona situation. One of our attendees asked, when you have a mechanics lien on a tract, what does it mean when you receive a notice of completion on a certain home lot?
Yeah, so owners often will do for tract development, and we'll talk a little about this later, but for tract development, they'll have separate projects. So if they have separate contracts upstream to construct either a full tract with several lots and several homes, or even on an individual basis, one by one, they can declare those as separate projects and record notices of completion for each one. So if you are clearly, whenever you get a notice of completion, you are going to stop what you're doing and make sure that you go ahead and protect yourself, because you're going to have a very, very short window in which to take action. So owners and contractors are free to do that as long as they have set it up correctly from the top, and they have set up separate contracts for the construction of these lots or these tracts. They can declare them as individual projects versus completion of the entire 36 home, 3 cul-de-sac development. They can actually parse those out into separate projects and shorten the timing for folks to enforce their rights on a much faster basis. Okay, so real quick, just to finish up the COVID-19 things. Again, it's really important you understand the conflicting state, county, local orders, looking at what conflicts, what doesn't conflict. I know we in Levelset are maintaining a database, every single county in California, what the shelter in place orders are, what the latest information is, so that if you need to find out, what do I do for a project what they're recommending to clients, whether you can go on site or not. We're probably more liberal as far as advising contractors that if you could keep your social distancing, that you could probably move forward on projects. It's all about definitions. It's parsing through the particular excerpts of the orders to figure out whether you fall in within the essential companies or essential infrastructure projects that are allowed under these various orders. And we posted a few of the excerpts that are up there, which do differ. So very important to figure out what the current orders are. One other thing I'll mention is that even if you can move forward on a project, one of the elephants in the room right now is a lot of the building departments won't inspect your project. So you're going to have a problem with moving forward on a particular trade, and then you're not going to be able to get an inspection unless you are doing low-income housing or something like that, there's a lot of municipalities that are not letting inspectors go on site. So even if you can work technically, if you don't have an inspector to approve your work, you might be stuck in the mud anyway. So you're going to have impacts that you may not foresee just because you think you fall within an exemption. If you are a contractor or a supplier right now, it's important to know what's going on in your project. Is your project one of those that's suspended? Again, chances are it very well might be. And so again, whether you're a contractor or supplier, understanding what's happening on your project is key. Picking up the phone, calling your customer, calling the GC, calling folks to figure out if this project's moving forward or is it suspended. Knowing the value of your labor and materials in place, capturing that screenshot of where you are at today. Potentially you have insurance coverage, business interruption insurance. It's a hot topic right now. There's lots of lawsuits that have already been filed regarding coverage issues here. It's important to talk to your broker and your attorney to see if you may have insurance coverage. And it's all about document, document, document. Put things in writing. If folks are telling you certain things about the project, if they are making promises, it's not, I know we like to do handshake deals in the construction industry. Now is not the time for handshake deals. It's time to lock things in writing, put them in emails, because 6 months from now, when you, if and when, God forbid, you are in litigation, you're going to want evidence, something in writing, and not just, well, we talked about this on March 25th and we said this or that on site. That's not going to fly. We need stuff in writing. So that's very important. As we're going to spend a lot of time today, it's protecting your project security rights. And we'll walk through these, the mechanics lien, the stop payment notice in California, payment bond rights. And even if you are a general contractor in the state of California, most of you probably have never heard of Civil Code Section 8700. It is unique to California. In fact, I believe we're still the only state in the union that requires owners to post a project security bond or letter of credit or some other equivalent for your benefit. And if they don't do that within 10 days of your demand, you can suspend work. And I know that when I poll my contractor clients, even my very large contractor clients, most of them have never heard of the statute, or when they have used it, it's on a sparing occasion. This is the time where if you are worried and need assurances about whether you're going to have funding in place, whether the owner is actually going to be able to pay for this thing, to maybe perhaps consider demanding project security under Civil Code Section 8700 from an owner right now. Lots of exceptions, lots of minutia in whether in those projects that are exempted or not exempted, but typically any large project falls within that Civil Code section. So think about that if you are a general contractor out there. Now, one other thing that we'll talk about is the need to make sure you get your liens down timely, especially because we are having county recorder's offices around the state of California and around the country, for that matter, that are closing. Not for business in perpetuity, but just for purposes of accepting deliveries or in-person filings. And so all that's doing is it's slowing down the process. You're going to have clerks that have socially distanced at the county recorder's offices to accept and open mail copies. So that's how things are being filed right now, and it's taking extra time. So you do not want to wait till the last day or the last couple of days to try to record liens or file lawsuits to protect your statutes of limitation, because there's a chance that it may not make it there on time. So very important that we get out ahead of these things and be proactive. And the one thing that I won't spend really much time with today, but again, if you are interested in the force majeure issues that pop up, I encourage you to tune in or watch a rebroadcast of another Levelset webinar that talks about force majeure and all the things that come along with that. But one thing I do want to point out, especially for you contractors, is making sure you understand what your contract says. Can you walk off? Can you get delay damages? Can you get an extension? It's all about your contract. What does your contract say? What does your force majeure provision say? Are you using an AIA form contract or another industry form contract, which typically is fairly favorable as far as recognizing force majeure, or not? And if you're a supplier, what is your contract? If someone's trying to cancel a order from you, which is going to happen if it hasn't already happened to you, can your customer cancel with no repercussions? Do they have to pay a restocking fee? Are you able to cancel with your manufacturer, your distributor? It's all going to depend on your contract documents. So looking back at your credit agreement, looking at the purchase order, perhaps your sales order confirmation or invoice. That's going to help determine whether or not you have the contractual right to excuse performance or get out of a contract that you might be in. And a lot of it comes down to UCC section 2615, which is the statute that governs the sale of goods around the country and in California. It's Commercial Code 2615 without the dash, basically. And it's all about commercial impracticability, and coronavirus and the impacts clearly would fall within UCC 2615 if it applies to your situation. Again, if you don't know if it applies to your situation, that's when you need to talk to your legal counsel to guide you with what your rights, duties, and responsibilities are. All right, with that said, let me move into the specific California Mechanics Lien law. And I'm going to start a little bit broader. A lot of you that are here watching or listening know already, you've heard about the Mechanics Lien, you know what that is. But a lot of you do not know or properly know how to use or consider other remedies like the stop payment notice. Stop payment notice, like 15 other states in California, is an essential remedy. It is one that you may not use on every single project, but it's one that's important that you consider and think about using. So this all falls within the umbrella of the Mechanics Lien statutes. The Mechanics Lien statutes in 2012 in California were moved to the Civil Code in the 8,000 section. They came from all different areas, really in the 3,000 section, and then we moved them, reorganized them. And the stop payment notice and the Mechanics Lien come together, and we call that all the California Mechanics Lien law. And same thing with payment bonds. It also falls within the same Civil Code area. And so again, when we talk about California Mechanics Lien law, we're talking about the lien itself, stop payment notices, payment bonds. And I like to throw in there, even though it's not really part of the Civil Code, the contractor's license bond claims. For some subs and for suppliers, this can be a way for you to collect on some of your smaller accounts, but it also gives you some leverage, as we're going to talk about down the road. We won't talk about today are things that you can find a lot of information about on Levelset's website and other webinars, like prompt payment penalties, making sure you consider that as an arrow in your quiver. Your contract rights, we're not going to spend any time today on that, and then potentially rights against third parties. Those are all things that again, we won't talk about today, but things that you need to consider as you're figuring out how am I going to get paid and who's going to pay me. These are the things that we're going to think about. Okay, and of course, if none of these things work, you always have a backup option, perhaps.
Charlie, you want to refill?
Yeah, refill be great. Hey, Mr. Clark, hey. You're tougher to get than the president.
Well, I've been busy.
Yeah, at least you could do is return my phone calls, though.
Listen, thank you. We talked about this, and I explained to you that there was the possibility you might have to take some kind of loss.
Yeah. I think I want my money back.
What are you going to strong arm me?
You know, I think you got no impression about me. I think in all fairness, I should explain to you exactly what it is that I do. For instance, tomorrow morning, I'll get up nice and early, take a walk down over to the bank and walk in and see. And if you don't have my money for me, I'll crack your head wide open in front of everybody in the bank. And just about the time that I'm coming out of jail, hopefully, you'll be coming out of your coma. And guess what? I'll split your head open again. Because I'm stupid. I don't give a about jail. That's my business. That's what I do. And we know what you do, don't we, Charlie? You people out of money and get away with it. Hey, you put my money to sleep. You go get my money or I'll put your brain to sleep.
Levelset's website, bottom right corner, that's what happens. Joe Pesci pops up, and you can hire Joe Pesci to go out to your delinquent customers and take a baseball bat. Just kidding. However, of course, most of us have wanted to do that from time to time with a particular customer that always is giving us the excuses. So one of the ways you get around that, of course, is making sure that you timely and effectively use your statutory payment remedies. I won't bore you with all the background details, but as most of you know, in California, the lien law is liberally construed in favor of contractors and supplier that pour their blood, sweat, and tears into our projects. So we look after our contractors and suppliers. We want to make sure that they get paid. And the law hasn't changed very much all the way from when the mechanics lien concept was first came about in the 2nd century, all the way when we made it a constitutional remedy in California in 1879. We had one major change again in 2012 where we reshuffled all the code sections. So for those of you that are still looking at, for instance, waivers and releases that say 3262, you're probably dealing with an unsophisticated customer that's still living in 2012 or before. And so those obsolete old forms should be thrown away. Of course, if you're the one that's being presented with the form to sign, so be it. It may or may not be enforceable, but we did undergo this major change in 2012. I don't foresee another one soon. Our hope, of course, is that we're going to move to sort of a Utah system where things are done more electronically than they are right now in California, but we'll see where things go. So one of the things that I always hear from folks that are still getting their feet wet with the mechanics lien law is making sure that they're uncertain or insecure about whether they are a proper claimant under California law. And so there's really a few prerequisites here that I'll talk about. One is, did your labor, or for you suppliers, materials go to improve the project? And this is one that is important, especially for the suppliers out there, because sometimes you are doing will call pickup, sometimes you are shipping to your customer's warehouse, you're not always delivering to the job site. It doesn't mean that you can't lien those amounts. It's all about, did your material end up at the job and did it go to the job? If it did, regardless of how it got there, you have a proper claim for those materials. Now, if those materials are still sitting in your customer's warehouse, where you're still holding them at your warehouse now because projects are suspended, then you cannot include that amount in your mechanics lien, at least not in California. The only exception to that really would be a federal project under the Miller Act. On federal projects located within California or anywhere, there is a good argument that you could include the value of specially manufactured goods into your lien claims. Okay, so that's first and foremost, is making sure that you understand the value of labor materials that went into the project, making sure that you're not willfully overstating your claim. Do not put lost profits or home office overhead in your claim amount. This is all about direct costs. And you are limited to the contract value or the reasonable value, whichever is less. So direct costs, not indirect costs. That's what we want to focus on. For you contractors, making sure that you are a licensed contractor is key. If you are unlicensed, you will not be able to use the mechanics lien law remedies unless you're a laborer. So important to make sure your license is active and properly maintained at all times. Separate 1-hour webinar about contractor licensing and making sure that you dot your I's, cross your T's, because as we all know, if your license becomes suspended for one day during the course of a project, you might be in trouble.
Chris, Chris, sorry to interrupt. We have a question. It's been a quiet crowd so far, but Zach asked, does water damage mitigation qualify as an improvement?
Sure, it sure could, absolutely. Yeah, so we actually represent a lot of restoration companies. So I won't tell you all the names of the folks that we represent, but we do have a lot of disaster mitigation companies that are considered home improvement contractors. So as long as you're properly licensed, then you should have a mechanics lien right. Good question. So as long as your materials went to the project, you haven't willfully overstated, if you're properly licensed, if you're a contractor, of course, suppliers do not have to be licensed. And as long as you follow the statutory prerequisites that we're going to talk about as far as time and form, then you are a proper claimant. Also, make sure that you are giving proper waivers and releases, as we're going to talk about. I know for most of you, you're familiar with this process. There's 4 forms in California, as there are with most states. You have conditional and unconditional waivers and releases, making sure that you're doing that properly, because one of the only ways that you can give up or release your rights is through those 4 forms. Okay, so super important that you're following that process correctly. I have on the screen as well, beware of DBE fraud. This is a hot topic that we talk about a lot, making sure that all of a sudden when a customer comes to you and says, hey, we've been doing business for 20 years, but I'm working on a public project and there's a DBE requirement, so you can't sell to me. You got to sell through this DBE. So please sell to them. We'll pay for it. Don't worry, we'll take care of it. You just got to sell through them. Beware that of DBE fraud issues. This has been a hot topic, especially back east, where a few companies got hit for several millions of dollars of damages. Innocent suppliers, quote unquote innocent suppliers, that got caught in the DBE fraud game. So be careful that if you're doing DBE sales, that they're legitimate sales. Again, a separate 1-hour webinar on DBE fraud that you all can jump in at some point where we explore all these issues, but very important there as well. So as I was mentioning, let me come back to the statutory releases, because these are the 4 ways that you can give up your rights. This and signing check and then passing it on to somebody else and they deposit that check. That would also probably be a waiver of your rights. But this is the main 4 ways, right? Are these 4 forms, and you all are familiar with them. If you're not familiar with them, it's time to make sure you understand the ins and outs of these forms. If you haven't been paid, you do not give an unconditional waiver and release. Never, ever, ever. We don't like to give these unconditionals until your check has cleared the bank. And that is something important. I know, especially in this day and age, we talked a lot about it around 2011, 2012 with our last economic downturn. I know as contractors and even suppliers in this industry that we often will exchange an unconditional in exchange for a check. We'll do that at the branch. We'll do that at the customer's job site, whatever it is. It's not a good practice. And I probably have 30 stories I can tell you that add up to $7 or $8 million of bad stories where checks didn't clear, and now there's nothing else that we can do as far as our rights. And that's why there's 4 forms that exist: conditional and unconditional. So it's important, if you have not yet been paid, that you use a conditional payment, especially when it comes to your final payment. And that's the one where contractors or owners are always hustling to get unconditional finals, right? They want to clear their project. The lender may require unconditional finals from everybody that's given a prelim. So you're going to get that pressure, and you have to have enough strength to say, well, wait a minute, guys. Look, I can't give you an unconditional upon final. I haven't had my check hasn't cleared yet. What I can do is give you what the California law tells you that I can give you, which is the Civil Code 8136 form. This form is designed exactly for the purpose of this situation, where I'm giving the conditional waiver release upon final payment plus the canceled check is an unconditional. And I promise that within 72 hours of when your check clears, I will give you an unconditional. But for now, I can only give you a conditional upon final. Super important that you hold to your own policy there and don't do an exchange for an unconditional. Some of you will still do it because you've worked with somebody for a long time, and I get that. It's a business decision in some sense, but know that you're always taking a risk. And the legislature has tried to help you by giving you this form to use. And sometimes, to be honest, it's an administration person that may be working for an owner or a lender or a GC that all they know is I need an unconditional, unconditional, unconditional. And they're not even really aware that this 8136 form exists. So it's our job to hopefully educate them and say, this is the form to use when a check has not yet cleared the bank. Okay?
Chris, just while you have a pause, we have another question from someone in the audience. It's from Janelle. If you're a metal fabricator with a business license but don't have a contractor's license, can you still utilize a mechanics lien?
So you will get a 50-50 answer on that. I bet you if you ask 100 construction lawyers in a room, half of them will say absolutely, and half of them will say I think you have a problem. I am more liberal with the way that I look at it. I think a metal fabricator, although technically probably should be licensed, it's the right thing to do to take out any arguments that your rule requires a license. I mean, there are specialty licenses that are described on the CSLB website. You can pull out the whole list of all the C special classifications that exist. And I would say that clearly you could find one or maybe even two where metal fabrication falls within some of those license classifications. But you could still take the more liberal view that as a fabricator, you're really a supplier. And as a supplier, you don't have to have a license. So we do that dance from time to time. I've argued that dance in litigation and in courts. So again, I think if you ask construction lawyers, we'll probably diverge and go different ways. So it really depends on who's asking me and the argument that I have to make, to be quite frank. Okay. So we talked about the waivers and releases. And as I mentioned before, it's all about following the guidelines of our statutes, making sure that you're timely doing a prelim, you're timely doing your claim, you are timely initiating your lawsuit if and when necessary. That's the foundation of how we move forward with all of these wonderful remedies that you have afforded to you under the California Constitution and the California Civil Code. Levelset does a great job with their graphics and their images. Here's a perfect example of the way they lay out the preliminary notice requirement. And as you can tell in California, like a lot of other states, we have a preliminary notice requirement on the West Coast. It's not just a West Coast phenomenon, but clearly on the Western United States, it is one that is typically required. In California, it's 20 days. 20 days before you furnish labor and materials is when you want to give your preliminary notice. In other words, once you serve that preliminary notice, it only goes back the prior 20 days and captures everything forward. So you want to do it as soon as possible. If you wait, gosh, I got to do a preliminary notice now. Again, it will only capture the value of the labor materials that you had furnished in the 20-day period prior to when you mail it out, and then capture everything forward. So we like to do it right away. Maybe when we sign our contract, our first invoice is going out, we're going to order specially manufactured goods right away. That's when we want to do the preliminary notice. No reason to wait. And the forms, there's lots of different forms. Levelset, again, has a fantastic a portal to get your information in there and get the preliminary notice issued. The one thing that you will always have to give to your provider, including Levelset, is your estimated total price. So that's something that Levelset can't guess about. You're going to have to give all the basic information, but also what is the estimated total price? And there's a lot of questions that arise about when you have to do an amended preliminary notice. So let's say initially your customer comes to you and says, I have a $5,000 order. Go ahead and prelim the job. Here's the job information sheet for the job. What happens when all of a sudden your customer comes back to you for the 7th time and says, hey, I need another order of fabricated steel. So we're at $120,000. Do you have an obligation to amend your preliminary notice? And if you haven't seen this yacht before, that is in somewhere in Northern California, it is a contractor's boat. And you can see the name of the boat if you probably squint down there in the bottom right-hand corner of your screen. The name is the change order, right? So clearly a contractor's boat that is very savvy, because if I zoom in here, the little dinghy attached to the big yacht is called the original contract. And that's probably the reality for many of you on this webinar, is that a lot of times what you start with is not what you end with. And in fact, your change order amounts swallow up your original contract. Now, for you contractors, that could be a bigger deal. That can lead us into a different area of the law if you're not getting paid. If your change orders are 10 times what your original contract amount is, that could be lots of different other legal issues that we need to explore. But for most of us,
Chris.
Yes.
Let me ask you a question. I have quite a few questions coming in. Do you want me to save those for afterwards, or do you want to handle them as we go?
I would say, Seth, you have ones that pertain to sort of the information we're talking about right now. Bring them, and if they're things that are sort of not on topic, let's save them, and we'll save 15 minutes at the end, and we'll rifle through as many questions as needed.
Okay, they're kind of, we're going quick, so some of them I didn't get to, but I'll go ahead and give you one or two now, just so we can keep the audience engaged. This is from Shamira. If the contract is broken down into payments, do you still give them a signed unconditional release, or not until the final payment for the project? We've gotten, well, we need the form to process the next payment. What do you do?
So I hope that this is familiar to most of you, and I'll go back to this graphic here. This is how the system should work, right? Where you're giving a conditional waiver and release to elicit your next payment, and then the following pay period, you're giving an unconditional release for the payment that you just got, plus a new conditional for the next billing period, and so forth until you get to the end. So that's the way it should work. You should only, again, be giving a conditional waiver and release if you have been paid and that check is cleared the bank. You should not be giving an unconditional unless that happens. So you're typically doing it, and most folks are doing it on a monthly basis, usually through the end of the month. It doesn't have to be, it could be a mid-month deal. And you're gonna use the through dates on your waiver and releases forms to indicate the date through which you are releasing your job rights in exchange for a potential payment. So use conditionals, but use unconditionals when required and when called for by your customers. Usually, again, one to procure the next payment, and then one to show that, oh yes, I have been paid, that check is cleared, so let me give you an unconditional to make you feel comfortable that that's happened. And that's the way it should progress.
And one more that's pretty straightforward. Someone had asked, can material costs be included in the mechanics lien from Dyna?
Yes. Yes, of course. And so one of the questions that we get from time to time is, well, wait a minute, I'm the contractor, so you're telling me I can include my supplier's claims, the value of their materials in my lien, and then they can go ahead and do a lien for the value of their materials as well. So isn't that double counting? And the answer is yes, it is. But that's the way it works, is that you as the contractor want to make sure you protect yourself. You're throwing in the entire value of labor and materials into your mechanics lien. And your suppliers are free to do just that, to record separate liens for the value of their materials in addition. So it does put an additional obligation and burden upon owners and general contractors, but that's the way it works.
And Tim had asked, the materials, since we're on this, material supplier, when requesting a preliminary info, can the information be filed by the supplier, a form to use, service to use?
So we're going to talk about job information in a minute. So hang with me. That's the next couple of slides here. Very important question. And if I don't answer it, please ask it again. But we'll get through job information in the next 3 or 4 minutes. Okay.
Great.
So
let you go.
Yeah, and feel free to interrupt me anytime. I mean, this is, if we were doing this live at the Beverly Hills Marriott, as we had planned to do, then that's how it would be. I would always take questions throughout. So happy to do so. So the question is, as I was describing, is if you have a situation where you have done a prelim and it's of $5,000, but now you're at $100,000 of total value, what do? Do you have to do an amended preliminary notice? I would say most construction practitioners in California would tell you no, and they might be right. However, I think our firm is of a different mindset. We believe the whole purpose of the preliminary notice is to make sure that you're protecting lenders and owners and general contractors from secret liens. We want to know who's on the project. And so because of that, if your amount is way off, well, what good is your preliminary notice? If you've estimated $5,000, but really you've got $200,000 of value in a project, then what good is that prelim? So I like the idea of following what we call the Arizona rule. In Arizona, they actually require you that if you hit 120% of your original estimated value, you must do an amended preliminary notice, otherwise you lose your right. Now that doesn't happen in California, and I would vigorously protect a supplier client of mine or a subcontractor client of mine if they got into that argument, because I don't think there is a requirement that exists today in the law, but I could certainly see a case being made upstream, and one day an appellate case coming out and maybe the legislature changing its mind because of exactly what I just described and what Arizona is doing, for instance. So in the rental equipment versus McDaniel case, and I'll briefly describe the case because I think it's pretty instructive. It was, and I'm going to play loose and fast with the facts here, but it was a rental equipment provider that was renting out lots of heavy equipment on a particular project. And by the time they got around to doing the preliminary notice, they already had something like $20,000 of equipment out on a project. They did a prelim for $10,000. And when you fast forward, when they did an amended preliminary notice, they did another amended prelim for another $10,000, even though there was now $150,000 of rental equipment out in the project. And when the mechanics lien was recorded, you pretty much know what happened is we had a very unhappy owner who was looking down going, well, wait a minute, how did you come up with a $10,000 prelim when you already had $20,000 of value out in the project? And then you did another one and you had $160,000 out in the project. How is that possible? And the credit manager in her deposition testified, well, I think it was a $10,000 kind of day. And that's just what all the prelims that I sent out that day were $10,000. And so that was their practice, was just use $10,000 as a number. And the courts have clarified for us that in California, you cannot just make up a number. It can't be made up out of whole cloth, as the appellate court said. You have to have a rational basis for that number, something. Usually it's your customer telling you how much in value they're going to need for a particular project. Maybe it's the contract amount, whatever it is. And if your customer's not sure, put the burden on your customer to give you something in writing, in an email. Do your best estimate so that I can rely upon it when I do my prelim. That's what I want to see upstream, is I want to get something in writing from my customer that tells me what the estimated total price is if you don't already have a contract price or some other basis to calculate it. You don't want to just guess, because that's what gets you in trouble, and that's what potentially can invalidate your preliminary notice. Okay, so let me come to a very touchy issue for many of you, whether you're a subcontractor or you are a supplier. Is I know a lot of you have had the same issue pop up of, well, if I do a preliminary notice, it's sort of an attack on my customer. My customer looks at me like, wait, you don't trust me? You don't think I'm going to pay you? I've always paid you. Why are you doing a prelim? And so there's not really any good reasons not to do a prelim. In other words, if a customer asks you not to do one, there's not usually a justified basis. It's either your customer's not sophisticated, your customer's lazy because they don't want to process additional paperwork like the waivers and releases, or your customer maybe is afraid of showing a large markup on, when it's doing its work and you've got a prelim. But remember, the prelim dollar value is what is an estimated value. There's just not a good reason. And one of the ways you can push back, especially if you are a subcontractor, and a lot of you probably do not know this, is that subcontractors must do a preliminary notice on every job over $500. No ifs, ands, or buts. And the law is very clear about this. This is Civil Code Section 8216. It's one sentence long. And again, I'm paraphrasing it, but every subcontractor in the state of California must serve a preliminary notice on every job over $500. And if you don't do that, it's an attack potentially on your license. It's a warning from the CSLB. The second time is a fine, and I believe it's the third time where you can lose your license. And the fines aren't small, by the way. They're $5,000, so they are pretty significant fines. And of course, you have a threat of 1 year in jail. I never heard of a story where a contractor's been thrown in jail for not doing a preliminary notice, but it does exist in the statutes, the penalty statutes that talk about what the penalties are for violation of 8216. So it's a very good excuse for you subcontractors to do a preliminary notice. And to be honest, there are sting operations that, well, at least that were going on before the coronavirus pandemic. There were sting operations where you'd have CSLB folks come to projects, do a walk around, look at whose trucks are on the project, look at the uniforms, and then do a audit of the preliminary notices that the general contractor had at its home office. And then they would compare notes and go, okay, well, wait a minute. Why do I have ABC plumbing and XYZ mechanical on this job site and you guys don't have a prelim from them? Well, let me call them and find out. And, oh, yeah, we didn't do one on this project. We've worked for this guy for a long time, so we weren't worried about getting payment. And the CSLB will say, well, that's not your choice. The law requires you to do a prelim. So this is your first warning. You do it again, I'm going to fine you $5,000. And that's how we started learning about this statute, because it really wasn't enforced until recently, where Sacramento had a lot of money at the CSLB, and we're sending out folks to do audits. So it's a great excuse for you subs to do prelims on all of your jobs. And it's not that difficult of a process, especially when you use a service like Levelset. They make it so easy and efficient and inexpensive. There's just really no excuse not to do a preliminary notice. Everybody does them on any major job, any commercial strip mall job, any tenant improvement. An owner and a general contractor is going to expect dozens of preliminary notices. So if you're not doing one, you're probably one of those few that aren't doing it. You should be doing it on all of your projects, especially if they exceed $500, which I imagine for most of you is every single job. And even for you suppliers out there, the 8216, this requirement that your subs do prelims, gives you a nice excuse. If people know your sub is out there, there's no reason for people not to know that you're out there. And again, owners and contractors like to know, who are my suppliers? Who's supplying the concrete or the electrical or the plumbing or the steel on this job? They want to know that. So you're not helping by not doing a prelim. In fact, you're probably frustrating folks upstream because they want to know who is on their project. So again, your job as a credit manager or as a project admin is to maybe educate the folks that you're working with that you're doing a preliminary notice, but you're not doing so out of spite or out of mistrust. They're doing it out of good business practices. And there's no reason why you can't toss on a nice letter, a little memo on your letterhead, on your stationery that says, you know, we are serving this preliminary notice. This is a formality. We do this on all our projects. You can dress it up. You can make it pretty, a little cover note or something. If you are worried, you can send your customer a separate email to let them know and let them know that you're not doing so out of, again, mistrust, but doing so because the law tells us that we should be doing it. Okay. So a couple of slides here regarding, I think the previous question as we get into job information is, I know a lot of the comments that we get is, well, it's just not easy to get project information. And it's easier perhaps than you think on most jobs. And it is something that is important, especially when you communicate with your sales folks, with your branch managers, with the presidents of your company that may be more focused on sales than they are credit, is making sure that we're all on the same team, and it's vital that we get project information up front so that we can protect ourselves and do the preliminary notice correctly. Now in California, the general contractor, who we refer to as the direct contractor as of July 1st, 2012, they are required to provide preliminary notice information for anybody that's seeking it. That's in the civil code. So a GC is not allowed to say, well, I'm not going to give it to you. They must give it to you. If you identify yourself as somebody that's going to be supplying or working on a project, they must give you preliminary notice information. Again, that's Civil Code Section 8208. You will find the lender information typically on the construction contract documents. You can ask the contractor, hey, I need a copy of your contract that shows the project and all the project players. You can redact pricing and all the other information. I just need to see that particular portion so I know how to do my prelim. The building department has records for lender information. The permits will show who the lender is if there is one on a job. County recorder's offices are all different as far as sophistication, whether you can get information online or you have to go through a title company or an attorney's office to get job info. I know Levelset can often dig up job information for you. So all important stuff in different ways that you can get product information. Now, one of the nice things in California, and this does not exist in a lot of states, but we actually have law. We have an appellate case called Forced Framing versus China Trust Bank, which allows us to rely upon a job information sheet. And clearly this is a fantastic thing for most of us that are used to this form. We may get this job information form on a general contractor's letterhead or stationery. Maybe it's a job information form that comes from our customer directly if they're a subcontractor. But regardless, this California appellate case stands for the proposition that if you rely upon the information and the information is trustworthy, even if it's wrong, the law is still going to probably protect you, the claimant, the quote unquote innocent claimant. And so while there's lots of case law out there that requires, and it's still a good idea, especially for high dollar projects, to do your own research, vet your projects, know who the players are, spend some time and money, especially if it's a significant order. You're going to want to go ahead and check county recorder's offices and check with the GC. You're going to want to take those extra measures. But the good news is that job information sheet that you get could be an important and vital source of information that can protect you. So I'll give you a few facts in the forced framing case just to illustrate how important it was to forced framing, but also to many of you that now benefit from the result of this case. And this is a subcontractor who had a job information sheet which showed that East West Bank was the construction lender for a particular project. So based upon and relying upon that information, forced framing sent out its preliminary notice to East West Bank, as well as the owner and the general contractor. Well, the project didn't go so well, and now the lender was looking to take over the project and basically get rid of all of the lien claims that it could. And one of the ways that it was going to do so with forced framing was to say, you got the wrong guy. We're China Trust Bank. We're the actual lender on the project. You got the wrong guy when you did your preliminary notice. Because we never got the preliminary notice, your mechanics lien is invalid. Sorry, forced framing. And the California appellate court said, not so fast, China Trust Bank. The law is liberally construed in favor and for the benefit of contractors and suppliers in California. We want to protect them. So even though the information went to an incorrect party, we're going to put the burden on you trying to trust me. We feel bad for you, but sorry, you're going to bear the burden of this, and we're going to still hold that the lien claim is valid if the information that was provided was quote unquote trustworthy. Okay, whatever that means. Whatever that means to 12 people in a jury box or to a judge in a black robe, whatever trustworthy means is what the law is in the state of California. So I would say when you get a job information sheet, and they are not created equal by any stretch of the imagination, it's important to look at it. Is it on the letterhead of a top 10 ENR contractor? Is it from your customer? That may not be so large or so distinguished, but still, does the information look accurate? If the lender information is blank, I think you got a problem. I think de facto it's untrustworthy, right? You have a duty to follow up and inquire and ask your customer in the GC, hey, the lender information here is blank. Does that mean there is no lender, or are you guys just not sure? So following up to get that information is key, all right? A couple of common mistakes that come with job info sheets is, in addition to having blanks, right? And again, with those, it's important that you follow up, especially when it says unknown. If you have something that says unknown, you want to follow up to make sure that, that you do identify the proper lender or the TBDs. But you'll often have a section on job information sheets that will say surety, and they'll list a ABC Insurance Services, Mary Jane, I shouldn't use that as an example, Mary or Jane Doe Insurance Company, okay? That is not gonna be the surety, the payment bond surety for a construction project. That's probably the broker. And the law tells us that service on a broker is not gonna be proper service upon a surety. So later on, when we talk about doing notices of bond claims, we're going to talk about how you have to send them to sureties and you have to send them to the general contractors or the principals of those bonds. You have to make sure that it's not going to the broker, but it's actually going to the surety. And most of us know who those sureties are. It's the same ones over and over again. It's your Continental Casualty companies. It's your Liberty Mutuals. It's your Zurichs. It's your Fidelity. It's the same ones that you're going to see over and over again, about 10 of them that pop up almost on every project. So those are the sureties that we're looking for, not ABC Insurance Services or something like that. Okay, so job information sheets, can't overemphasize that those are super important in California. And thankfully, the forced framing case gives us a lot of ammunition to use when the job information is incorrect. Again, it's not an excuse to put your head in the sand. If you have a bad job information sheet, you should follow up on the larger jobs, but it's a nice piece of law that exists to protect subcontractors and suppliers. I will rifle through some of these fairly quickly because I know most of you already know the basic timing on preliminary notices. Again, doing it within the first 20 days, very important. Talking about the mechanics lien itself. Again, most of you are familiar with the form. It's a 3-page form as of 2012. It's not just the mechanics lien itself, it's the proof of service affidavit and the mandatory language. If you're using Levelset, one thing you always will know is that they are using the latest and greatest updated forms. When you're doing them on your own, one of the biggest worries is that you're using an old form. And I see this a lot from some of my smaller contractor clients that come to me that say, I haven't done a lien in 10 years, but I need to do one. And so I did one, I need you to file the lawsuit. And I look back at the form and it's an old form that doesn't comply with current law. Most likely, if you use an old form, it's not gonna be good. So I strongly suggest that you're using the new forms or use a service like Levelset that will help expedite your mechanics lien, and they'll do it right. Okay. Couple of prerequisites that some of you may or may not know is that you always need to serve a copy of the mechanics lien before you record it. That is something that's required. It doesn't mean that you can't do it the same day. You could drop it in the mail by certified mail and then run to the county recorder's office and get it recorded, at least when they're open. That's how you could do it. But that is a two-step process that now exists. And you have to file your lawsuit to protect that mechanics lien within 90 days. If you do not do so, your mechanics lien is stale. And now you've turned your security and leverage into a liability because there's a civil code section that exists which allows owners to use it against you to say, hey, your mechanics lien was recorded 92 days ago and now it's stale. You haven't filed the lawsuit So now I want you to remove it. And if you don't do so within 10 days, you're going to pay my attorney's fees when I file my petition to have your lien expunged. So I see this a lot amongst suppliers and some unsophisticated contractors that go, well, I'm going to leave my lien out there for as long as I need to until I get paid. It doesn't work that way. And unfortunately, if you leave your lien on too long without filing your lawsuit, that's when you get in trouble. And now the tables have turned and the owner and the GC have leverage over you. All right. Couple of other things that you may not know about the mechanics lien is that you have to be done with your work in order to record your mechanics lien. You have to cease performing your labor and materials. Now, this is very important in this day and age of coronavirus, because if your project is being suspended or terminated, you need to make sure that you have an understanding in writing with whoever your customer is, that that is the case, because you don't want to be in a situation where you are prematurely recording your lien, like what happened to Precision Framing Systems last year, where their lien was thrown out because they still had a few $1,000s of work to do when they recorded their mechanics lien. So again, excuse me, the lesson is you must be done with your furnishing of labor and materials to record your mechanics lien. Now that may mean for your projects that are suspended, for you to issue some sort of notice. It could be a deductive change order for the balance of your contract to say, hey, because of the suspension and because of the need for me to protect myself, I'm going to declare that I am done at this point. However, if you want me to resume and finish up the rest of the work, I will do so pursuant to a separate contract or change order. You could do something like that with your attorney's assistance, but it's important that you don't just record your mechanics and if you still have work to do without thinking about that. Okay, very important because of these project suspensions that you go about recording your lien the right way and don't do so prematurely. Now, notices of completion are usually a topic that we spend a lot of time on because if you get a notice of completion, even though they are still somewhat rare, they're more common on public projects, it shortens your time frame. So by the time you get the copy of the notice of completion, you may only have 20 days to record your mechanics lien, or else it's too late. Direct contractors have 60 days. So whenever you get a notice of completion, you pretty much want to stop what you're doing and say, oh, I got a notice of completion. I'm still owed X number of dollars. It's time for me to go ahead and record my mechanics lien. Now you have to be given a proper notice of the recording of the notice of completion in order for it to be effective. If it's not sent to you, then it's invalid. Okay, and you have 90 days to record your mechanics lien. So it only can shorten that window if it's properly done and timely sent to you. And there's lots of rules about notices of completion and whether they're effective or not. I will tell you in my experience, more than half of the notices of completions that I see are invalid. So just because somebody tells you, well, here's the notice of completion, your lien's too late, you got to take it with a grain of salt. Most likely they haven't followed every I and dotted or crossed every T in the process, so take it with a grain of salt. But when you do get it, it's important to act quickly. All right, and if there's no notice of completion, then typically all claimants have 90 days from actual completion to record their mechanics lien. California is one of the few states that does follow the lien calculation from when the project is complete. This is very different in most states and different in federal law, where we follow, you have to do your bond claim within 90 days of when you last furnish. That's not the way it works in California. For better or for worse, we have more time. And so some of our customers expect that you're going to be more patient on your end to record your lien. So your lien deadlines, again, run from when the project is complete, not just from when you're done with your scope. Now, one important thing that we're going to talk about is what is completion? And we could spend an hour on this topic alone. I'm going to just dive into it really quick. Completion is an amorphous concept, and nobody can tell you any different. No lawyer, no construction lawyer can perfectly identify when completion is, especially with this new precision framing case that came out last August. It's really muddied the waters for us to try to figure out when completion takes place. Typically, we consider completion when the actual work is done and the building is occupied. That's typically what we think about when we hear completion, but it doesn't mean punch list work and callback and warranty work extends that trigger in perpetuity. There is a cutoff. And so we'd like to differentiate what is work that still needs to be complete. In other words, work that's required by the plans and specifications of a particular job that still is not done yet, versus all the work is in place. And now we're just doing callback, pickup sort of work, punch list work that's really remedial in nature, okay? When we're at that stage, the project is already done. So when you're already in that punch list phase, not because there's work that's missing, but work that just needs to be repaired, you already have a completion most likely under California law. So that finding that balance is important. Sometimes it is, to be honest, if you're a early trade contractor or you are a supplier, it is contacting your customer or the GC and saying, hey, I know we're waiting on 10% of our money still. It's been a year. We're not really sure what's happening on the project. And somebody upstream says, oh, well, don't worry, be patient. The project is there's still punch list work going on in the project. That's a concern, because you know that punch list work may indicate that the project is already done. Okay? You want to know what type of punch list work still needs to be done. Is there missing work? Is there still some of the finishes that need to be installed on the project that haven't been done? Does it still need to have a second coat of paint? Okay, are there things that are required by the plans that haven't been done? In that case, you may still have time. But if the punch list, again, is all remedial in nature, then your completion has already occurred. So what I like to do is ask for a couple of documents. Usually it's the punch list itself that should be readily available to all trade contractors that are working on the project towards I also like to ask for look-ahead schedules. You know, give me your latest 3-week look-ahead schedule, because those sort of documents give you an idea of where the project status is and give you some comfort or discomfort in identifying, oh, wow, we are at that time where I got to go ahead and move forward my mechanics lien rights. And the final thing that I really want to emphasize here, again, with the coronavirus impacts, are chances are with 30 to 50% of projects being suspended, that you're going to run into a statute that we really haven't seen for quite a while. This statute takes greater significance when we have economic downturns. I've been practicing for 20 years, so I've seen 2 to 3 economic downturns, including, of course, about 8-9 years ago, where we had projects that were being mothballed or suspended, contractors being kicked off of jobs. And this is the last time we saw cessation of labor issues. So understand this. If there's one takeaway for those of you that are okay, I'm sophisticated, I know this mechanics lien stuff, this isn't really new information for me. A lot of you do not know that if there's a cessation of labor for 30 days, 30 straight days of no work on a job, which is quite likely in the state of California right now, if that happens and an owner sends out a notice of cessation of labor, then you have now your clock ticking for you to record your mechanics lien or serve your stop notice. You can't just wait, okay? Your trigger is going, even though there's no roof on the project yet, there's no windows, it doesn't matter. We have a completion. And when the project resumes, you've got a brand new project. So it's either 30 continuous days plus the recordation of a notice of cessation of labor, or 60 continuous days of cessation of labor. And it's a trick that a lot of takeover sureties will use. They kick off a contractor, it's been 30 days, they're trying to find a new contractor, it's been 45 days, and they go, well, wait a minute, new contractor, just hang on a second. Let's wait another 15 days, because once we have 60 continuous days of no work, I can now use my elbows and try to kick off all of those claimants that are trying to assert their rights against the project, because they're going to be too late if they don't record their mechanics lien timely. So super important that you understand the cessation of labor statutes that, again, have not really kicked in for many years, but now they're going to be of importance. If you are on a suspended project, all right, how am I going to secure myself? And it may be going ahead and move forward with mechanics lien or stop payment notice remedy. Okay, let me move quickly. I'm going to skip through a couple of my wonderful video clips here for benefit of trying to get some more information in here. Again, things that you do not know about, because I do a lot of these seminars and webinars, and what I realize is when I talk about some of these topics, I I'm getting the impression that maybe we're not doing a better job in the construction industry of pushing ways that you can protect yourself. It's not just the mechanics lien. The stop payment notice is key. And the stop payment notice is key because it is a complementary remedy. So on public and private jobs, you can use a stop payment notice remedy. And I know a lot of you know that if you do public works, you go, oh yeah, I know I can do a stop payment notice, and that's what I do. But you also can do them on private works of improvement. Okay? So very important to think about it. It's a different remedy. The lien is passive, right? You all know that. The lien is like a mortgage. It sits on title. You may have an owner that really cares, or you may have an owner that's, all work itself out over the next year, and they're not going to really take much action. When you do a stop payment notice, it's really an attack on the construction funds of the project, meaning they're going to have to deal with you. So if you want that sort of attention, then you're going to do a stop payment notice. And so for public or private, it's going to go to the person who's holding the construction funds, whether that's an owner-funded job, it's a construction lender, or in a public project, whoever the dispersing officer is. That's who you're going to send the stop payment notice to, and it acts as a lien on the construction funds. All right, something very important to consider. Again, you may not use it on every one of your jobs, but at least consider whether it's an appropriate thing to do. Now, one important difference between the lien and the stop payment notice is that you can serve it at any time. You don't have to wait until you're done, like the mechanics lien. So you can serve it even though you still have another $100,000 of work to do, but you can only, on the amount due, include the value furnished to that date of when you're sending the stop payment notice. You can't send it for the entire work that's not yet been done, okay? This is an important distinction here between the mechanics lien and the stop payment notice.
I don't want to interrupt an important point, but we do have a ton of questions, which we'll get to as many as you can, but just you let me know when you're ready to wrap up. So, because I know the audience wants to participate, because after all, this was supposed to be a live event where we could have answered some more questions. But whenever you're done wrapping up, I'll kind of do some rapid fire questions at you. They're all over the place. I don't know a better method to go, but you can give them, 30 seconds apiece if appropriate. Some are quick, some are not. But go ahead. Sorry to interrupt, and just let me know when you'd like to start the Q&A period.
No worries, Seth. I know I'm talking fast. I apologize. I'm trying to get as much information as I can in for folks to hear and hopefully help. So I'll wrap up in about 6 or 7 minutes. So we'll be done. We'll be done by 9:47 or so. And again, I'll stay as long as people want to ask questions. I'm here to help in any way. So a couple other issues about the stop payment notice, and I won't go into great detail about it because it can get super complicated. So again, public and private projects. On public jobs and an owner-funded private jobs, all you have to do is fill out a one-page piece of paper and serve it with the proof of service. That's your stop payment notice, okay? Using the right form, of course. Now, Levelset, fantastic resource, fantastic way to easily move forward. Like Bank of the West, East Bank, Wells Fargo. You can still do a stop payment notice, and the bank may on. However, unless you go out and get a bond, the bank or the lender decide to ignore your stop payment notice. So this is an important little clarification here for lender private jobs. So when there's a third-party construction lender, you want to make sure that the lender honors your stop payment notice and takes your money and sets it aside for your benefit. You may have to go get a bond. And that bond, as most of you that are sophisticated in the industry know, bonds are usually about 1.5% premium. It can be significant. So if you have a $100,000 claim, you might be spending $1,500 to go get a bond from a surety. And you go through a broker. There's lots of great brokers out there, the Locked-ins, the Marshes out there, and there's lots of smaller brokers that know how to do this. You can get it issued typically 48 hours or so. You attach the bond to your stop payment notice. Now the lender has no choice but to set aside your money. And the huge benefits of doing it that way is, number one, the lender now must set aside your money or face personal liability for your claim. They don't have a choice. And even if, and this happened a lot 10 years ago, even if they say, well, sorry, we're going to wipe you out. There's no money left in the construction fund. We only have $50,000 left. There's claims that are like $1 million on this project. Sorry, you're much. The lender will have to reach into its own pockets under, I think it's a 1985 case called Familian pipe and supply. They have to go into their own pockets and put back on the table construction administration fees, points, and other things that it's paid itself during the course of the loan. Those become subject to your stop payment notice claim. Lenders hate when you do a bonded stop payment notice. And the second thing is, if you win, if you're the prevailing party, you get to recover your attorney's fees. You don't get to recover your attorney's fees on a straight mechanics lien claim, but you do so on a bonded stop payment notice claim. So a couple of really important points about that stop payment notice. Always consider it. Always consider using it as a complementary remedy when you're doing your mechanics lien. You encourage you to do it. They don't want to be the bad guys. They want you to be the bad guys in enforcing your claim upstream and you throwing your elbows to help you and also them get paid. For public projects, right? Everything over $25,000 has to have a payment bond behind it on a public work improvement. And there's a couple of exceptions, but that's pretty much the way we look at this. So any public job over 25 grand, you know there's a payment bond there for your protection, typically issued by the prime contractor and its surety. Sometimes you'll have subcontractor bonds that are out there. So it's not just limited to the general contractor. But increasingly, especially in California, you have payment bonds on private projects. And if you don't ask, you might never know that there's a payment bond on private jobs. The larger the job, the more likely there is that there's a payment bond. Again, even on a private work of improvement. So it's important to know if there is a payment bond available for you. And if there is one, that you use a notice of claim to surety and principal form. So it's a one-page form. It looks like the mechanics lien. It looks like the stop payment notice. It goes to the principal of the bond. Again, it's almost always a general contractor. It doesn't have to be, but it almost always is. Plus the public entity. When they get this form, you've now made your claim, and the surety will respond to you within 15 days under the California Insurance Code regs. They will be responsive. They'll ask you to fill out a form to provide supporting documents, and you'll walk through the claim with them and hopefully establish your place in your security. Now, one beautiful thing about the payment bond claim is that even if you did not do a preliminary notice, you still may be able to do a payment bond claim, private or public. There's a couple of exceptions with the preliminary notice requirement. One of them is for payment bonds, you can still do a notice of claim after the fact, up to 75 days after the project has been complete, and still do a notice of payment bond claim, even though you never did a preliminary notice. If there's a notice of completion, that time window shrinks to 15 days. But still, at the end of the job, you can do a notice of payment bond claim, even though you never did a prelim. And the other exception that we didn't talk about earlier is on public works. If you are in direct privity of contract with the general contractor, there is an exception for you. You may not have to do a preliminary notice. I always tell my clients, you always do it. But that may be a loophole if you are a sub, a direct sub, or even a supplier to a GC, and you didn't do a prelim, you still might be able to move forward or a payment bond claim, even though you didn't have that prelim. Okay, so very important to make sure that you know that the payment bond claim exists on, again, all public jobs and many private jobs. And know that if you can't get the information from the GC or from your customer, especially if it's on a public work of improvement, the public entities want to give you the information. They don't want stop payment notices on their job. So almost always you can do it by email, give them a call, ask for a copy of the payment bond, and they're pretty responsive. Usually within a few hours or within a few days, you'll get a copy of the payment bond issued for a project, even though the GC or your customer may not have it or may be reticent about giving it to you. All right, and with that, Seth, I want to leave some time for questions here, okay. But I want to emphasize that even if you've done it all right, that you, at the very end of the day, you have a short window to enforce your claims. And it could be as little as 90 days from when you record your mechanics lien. If you haven't filed your lawsuit to perfect your right, you may have lost your mechanic lien right. So it's not just setting the table, doing the prelim and doing your claims timely, but then enforcing your claim down the road with your counsel is making sure you do that quickly, not waiting till the very last day, because again, with court closures, it may be difficult to get things filed same day, especially in those counties that don't do e-recording. All right, with that,
Chris, yeah, let me ask you, are you able to see the Q&A questions that have been typed? It may be easier for you to read them than for me to read them to you.
wow, yeah, we have a ton, don't we?
At the bottom, it says Q&A. Yeah.
All right, so let me rifle through as many as I can quickly, if that's okay. And again, I'll stay as long as people are interested. So let me go through. I've got probably way more than we can
Great,
hear.
thank you.
Let me pick out a few. First one is, what can a GC do when a sub liens a job without a preliminary notice? I know it's legally not valid, but it has stopped our payments from the owner in the past. Well, that's a situation where you send a nice, nasty letter to that subcontractor demanding a release immediately or else. And there are cases, there are procedures that we didn't really explore today that you can use. There are some motions and some petitions that you can file, especially if it's a lien that's done in bad faith, where you might be able to get your attorney's fees back from that subcontractor. And so I would suggest going to a construction lawyer to have them draft you a one-page nasty letter. Typically that'll do the job. So that's my suggestion. But you're right, if your sub had to do a prelim and didn't do a prelim, that might be an avenue that you want to pursue and scare them off their claim. And again, one of the exceptions though is on a public job, if you're the GC, your sub may not have had to do a preliminary notice. Second question, is California 20 days from the start of the project as a whole or 20 days from the subcontractor start date? Good question. It is from the start of when you furnish your labor and materials, not from when the project has commenced. So you may be the roofer that doesn't get involved until a year into the project. Within the first 20 days of when you walk on site, you should have your preliminary notice down. Okay. Also wanted to ask if the 20 days has passed from the start of the job, can we still go ahead and put a lien on the project? So again, that will depend on if you are in the middle of a job and you go, man, I didn't do a prelim and I had to do a prelim. Well, do a prelim now because it'll still capture the value of your work 20 days in the past and everything forward. But if you're required to do a preliminary notice and now you're facing that situation where you're done and you haven't done any work in the last 20 days and there's nothing to capture by doing a prelim, you still may want to consider doing a mechanics lien, but you have to do so with some basis. I wouldn't just do it. I would never recommend somebody doing a mechanics lien if you've got no basis to do it. There are some ways, some creative ways with your legal counsel to try to get a claim down, but you may be stuck with your old-fashioned contract rights in pursuing your claim. And there's lots of little exceptions that you might fall within to excuse your lack of preliminary notice, but I wouldn't do it if there is absolutely no basis to do it. I got a question about Washington law. We actually have some slides and another presentation about Washington lien law, similar but very different as far as timing goes. So I would suggest wait until Levelset does a Washington lien law seminar, or give a Washington expert that you find a call because they can quickly answer your questions there. Retention, yes, no, for purposes of conditionals and unconditional. So you'll notice that in your conditional waiver and release forms, one of the built-in exceptions is for retention. So they'll say, include the value that you're owed, but retentions are not waived. So look at that form and make sure that you're using the right form that has a carve out for retention. And if so, you can safely give the amount due for your next progress payment, but still preserve your right to retention payments. But then as you move forward, when you get to the end of the project, you don't give an unconditional upon final until every dollar has been paid, including retention. So those final releases contemplate full payment, every dollar, including retention. The progress payments, however, are the ones that usually carve out retention as an exception. Next question, do you have to send a preliminary notice when contracting directly with the property owner? Fantastic question. So the law was clarified in 2012, and we actually represented a contractor in that situation in the appellate system. And it was that prior to 2012 that you probably had a good argument that you did not ever have to do a preliminary notice when you were in privity of contract with an owner. And that still could be the case. However, the law is very clear that if there is a construction lender and you don't serve a preliminary notice, your mechanics lien is not valid, at least against the construction lender. So yeah, you have to do a preliminary notice even if you are in direct contract with the owner if there's a construction lender. We always suggest you do a prelim on every job, no matter what. You never know sometimes if there's a lender behind the scenes that you weren't made aware of. So we always suggest doing a prelim. And as we said earlier, every job over $500, we suggest you do it, and the law requires you to do it. So, but yeah, you may have an out if there is no lender and you are in privity of contract directly with the owner. Are prelims required on public works projects as well? Well, as I mentioned, they are required on public works jobs. There is an exception. If you are in privity with the general contractor, you may not have to do a preliminary notice. When do suppliers have to send prelims? Are they required like subs? Absolutely. Prelims are required for material suppliers. And again, they should be sent within the first 20 days of when you furnish materials right away. Don't wait on your preliminary notice. Okay, I think we've addressed some of this stuff. Let's see, if you are working with the federal government, how am I to include the lender on my prelim? So federal jobs are a little different. We didn't talk about federal jobs today. Seth, I know, I'm sure you, Levelset does webinars for federal Miller Act bond claim projects, and we'll clearly do one in the future if one is requested of us. We represent contractors and suppliers to federal projects all the time. So there is not really a preliminary notice requirement for you on federal jobs. It's all about the Miller Act bond and making sure that within 90 days of when you last furnish to a job that you send out your Miller Act notice to the contractor by FedEx or certified mail. We always like to send it also to the surety. I think it's a good idea to send it to both. So it's all about Miller Act, no preliminary notice requirement unless the contract docs require you to do a preliminary notice. All right, another good question here from a GC. What can I tell subs that threaten mechanics liens prematurely? Also, what happens when they file a lien prematurely? So it's a tough question. It really depends on your project. As we talked about, folks should not be doing mechanics liens until they're done with their scope. However, if they're not getting paid, one of the arguments you're clearly going to hear is, well, look, we haven't been paid. So you have breached the contract by not paying me on time pursuant to the contract pay schedule. So therefore now I am within my rights to suspend my work and do my mechanics lien. You're going to hear lots of things like that depending on the specific factual nature of the issue of the dispute. But that's really the requirement, is that you are done with your scope, or at least you have declared that you are done, or the other party has breached the contract before you record a mechanics lien. There is a way to challenge premature mechanics liens as precision framing learned in the appellate system. Can stop payment notices apply to insurance proceeds? Great question. I haven't gotten this question for many years, but absolutely. Whoever is holding construction funds, and oftentimes you're right, especially during the fires that we had in Northern California and down here in Southern California, it's a big source of construction funds. You can do a stop payment notice for funds in the hands of insurance carriers. All right, I think I have a bit more questions on the preliminary notice. What happens if we send it too early? There really is no such thing as sending a preliminary notice too early. You can send it as soon as you want to be quite honest, as long as you can rationally estimate the value that you're going to furnish to the job and you've got the proper job information. No such thing as a too premature job information sheet. Will the slides be available offline? Awesome content, but we are rushing through. Yes, we are rushing through. We like to do 3-hour seminars at times with lots of jokes and video clips. We didn't have a chance to do that today because I wanted to make sure that we hit some of the coronavirus stuff too, that I know is impacting folks, and emphasizing that. But yes, the slides are going to be available online, and I think a video rebroadcast of this webinar will also be posted on YouTube. If you want to see the one that we did on Monday, that's also on YouTube right now, posted through Levelset, where we really emphasize more the contract and coronavirus impacts, how force majeure works and all that. So for you GCs and for you subs and suppliers, an important seminar perhaps for you to get into, where we really focus more on coronavirus. All right, let's see. A couple more questions here. We still have a little bit of time, Seth. A couple more minutes. Okay. So question is, on the stop payment notice, you said it only covers up to the date on the notice. So are we to stop working when we issue a stop payment notice? It depends. You don't have to. You can still work, and that's the beauty of the stop payment notice. You can do your stop payment notice and still be working on the project, again, only including the value through the date of your stop payment notice. But it doesn't mean that you have to stop work, unlike the mechanics lien. So it's a great clarification for purposes of the stop payment notice. Let's see. Let me try to find one more here. A lot of good preliminary notice questions.
There's one or two questions in the webinar chat if you want to check that too, Chris.
Oh, wow. Yeah. Okay. Let's see here. Questions everywhere. So are GCs required to provide bond company and bond information for public works projects? Yes. It depends who you're asking, but yeah, certainly. I think that's a requirement that's implied in the California Civil Code. And if they're not going to give it to you, there's an easy place to get it. It's calling the public entity or sending them an email. And again, they're really responsive. In my experience, I've never, in the last 5, 6, 7 years, had a situation where a public entity says, oh, we can't find it, can't get it to you. They want to give it to you because they don't want to stop payment notice on the project. And they usually email it to you. So that's the good news. If you're having problems, you can do a Public Records Act request. It's a one-page letter, basically offering to pay the public entity its reasonable costs of copying the bond information that you're requesting, and they get it to you within 10 to 15 days max. So that's the worst case situation. Can you file a mechanics lien on change orders due if the owner has fired you at 95% completion of the job? Absolutely. If you perform the work, you have the right to the mechanics lien. It doesn't matter if it's in dispute. It doesn't matter if it's a pending change order, it's a PCO or a change order that hasn't yet been billed. You're going to include in your mechanics lien all of the value of the labor and materials you furnish to the project, regardless of whether it's been billed or unbilled. Okay, so don't be afraid of not including change orders in your mechanics lien. You absolutely should do change orders, include change order value into your mechanics lien claims. Again, another insurance question. If the insurance company is providing funds, does the stop payment notice get sent to them or the owner? To be quite frank, I do both. If I'm at the point where I'm doing a stop payment notice, I want to serve everybody that has a potential ability to get me paid. So I'm going to serve both. The important target, of course, is the person that's holding the funds. So in this case would be the insurance carrier, but I definitely want the owner also to be subject to the stop payment notice, because if they're folks that are holding funds, I want them to have to hold construction funds for my benefit. So you as the contractor may not exactly know how the money is going to be paid downstream. It may get cut from insurance carrier to owner to contractor. It may not go direct from carrier to you, and the owner may have some funds. So you may want to have both of them as proper targets. Another question, and I hope I touched on this clearly enough. When can I file a stop payment notice? Anytime you want, again, for the value of your labor and materials furnished through that date. Now, if you're asking on the late end, like how long do I have to file a stop payment notice? The good news for you is that it dovetails with the mechanics lien law. So you have basically at least the same amount of time to serve a stop payment notice as you do to record a mechanics lien. And on public jobs, you may have longer. It gets a little bit complicated. You may add another 30 days to the mechanics lien timing that you would have on a private job, but you got at least the same amount of time, if not more, to do a stop payment notice. And you may have several more months to do a payment bond claim, up to 6 months after a job is complete, to file your lawsuit on a payment bond claim. You still want to get that notice out, that 1575-day notice that we call it, the one that I showed you. It says notice of claim on payment bond to surety and principal. That one you want to get done as soon as possible, and usually no later than 15 days of when a notice of completion is recorded, or 75 days after actual completion. When can I get a copy of the program? Well, I'll let Seth, when can I get a copy of the PowerPoint? I'll let Seth answer those questions about when this webinar will be posted.
We'll be following up with everyone that was a participant today. And I guess we're almost a little bit over 5 minutes over now, Chris. So I know you got to most of the questions, so it's probably time to wind down, and I'll give you another minute or so. And then if you have other questions, go ahead and post them on the Expert Center in your particular area. Chris can get to them, or another lawyer can get to them, or another expert if it's in an accounting person or an engineer, but mostly lawyers. So go ahead and go to the Expert Center, post some questions if you haven't heard the answer that you posted today, or if anything else comes up, that would be great. And Chris, we really want to thank you again for doing an excellent webinar 2 in 1 week. And we're sorry we weren't able to see you and meet all these nice people live in Beverly Hills. As soon as our epidemic or pandemic subsists a bit, we will be back in Southern California doing one live. So Chris.
Yeah, it'll be exciting to see you all in person. I always like to do seminars in person. It's great to answer questions live. And we will give you extra rubber chicken lunch and lemonade when we see you at the hotel. So I just want to thank Levelset. Really, I want to make sure that folks know that Levelset's doing something extraordinary. AGC is doing a really good job too at helping contractors, no doubt, with their updates. But Levelset has a survival kit on its website to survive the coronavirus pandemic. They've got great resources for a lot of you that don't already know. When you Google construction help in California, usually Levelset's going to be your first or second result that pops up. They are on top of things. They are using a database of experts like ourselves around the country to help folks in particular jurisdictions. So there's no replacement for good information, and you're getting a lot of that through Levelset. So thanks to the folks at Levelset. Thank you guys for joining today. Any questions, comments, always around. We are working remotely, even though we don't have our physical offices. We are up and running. My wife would say that we're working too much. In fact, she goes, you were working less when you were working in the office. And now that you have you're working too much. So we are here to help you navigate coronavirus and the impacts and answer any follow-up questions. So with that, be safe, stay healthy, and we'll talk again soon.
Everyone stay healthy. Thank you, Chris. So we really appreciate it. You have a nice day. Bye-bye.